C.D. Okafor.
Yes.
Most humbly appear for the appellants. Thank you, my lord.
Yes.
My lord, most respectfully,
Yes.
I am Kehinde Edu,
Yes.
appearing with O.V. Akowe and President Dibia.
Yes.
My lord, we are for the first respondent.
Yes.
My name is Chief Samson.
With the kind permission, I'm holding the brief of IG Waru for the second respondent.
Yes. Judgment. A panel of 5 that consisted of Manana brothers John Iyan Okoro JSC, Heli Moro KG Ogunbidu JSC, Tijani Abubakar JSC, Haruna Simon Samani JSC, and Mohammed Baba Idris JSC sat and had the appeal. The lead judgment was written by Manana brother John Iyan Okoro JSC, and I read this judgment on his behalf. The appeal is against the judgment of the Court of Appeal, Abuja holding at Abuja, in appeal number CA-ABJ-CV 2017-2024, delivered on the 17th day of January 2025, against the judgment of the Federal High Court in suit number FHC-ABJ-CS 1271-2024, commenced by the first respondent at the trial court, wherein the suit at the trial court was struck out for want of jurisdiction. The facts that led to the appeal has been captured in the body of the judgment. Having reviewed the arguments of counsel, the court unanimously agreed as follows. The court held inter alia that the court below, having found that the first respondent's main relief was relief number 5, which was predicated on the leadership of the first respondent and thus not justiciable, strayed beyond the jurisdiction into the realm where even angels dread to tread, to pronounce Barrister Julius Abure as the national chairman of the first respondent. Their lordships of the lower court were wrong to so do. The principles of law applicable here is as expressed in the Latin maxim that no one puts something on nothing and expects it to stand. The first respondent suit at the trial court had no legs to stand in the circumstances and deserves to be struck out. Allow me just at this point to reiterate the tried position of the law that if a court of law is bereft of jurisdiction to entertain the main relief in an action, it do not have the jurisdiction to entertain the ancillary claim, and moreover, if the ancillary claim will inevitably involve a discussion of the main claim, as in this case, Situkur and Government of Gongola State. The 3 issues submitted for determination are hereby jointly resolved in favor of the appellants. In summary, both the trial court and the court below had no jurisdiction to entertain the suit of this first respondent, which main relief, as they both rightly observed, was inserted as relief number 5 as though it was an appendage. Consequent upon the foregoing, the decisions of both the trial court and the court below, recognizing Barrister Julius Abure as the national chairman of the first respondent, are hereby set aside. And suit number FHC-ABJ-CS 1271-2004 is hereby struck out for want of jurisdiction. In the same vein, the first respondent's cross appeal in appeal number SC-CV 56A 2025, being an offshoot of the same judgment of the court below, is hereby dismissed. Before I'm done, may I admonish political parties and their members to endeavor to always allow their constitutions, rules, regulations, and guidelines to guide them in choosing their officers as well as candidates. That way, incessant internal rifts which always find their way to court will be reduced. If the constitution of a political party has prescribed duration for tenure of office of an officer. Such officer should be humble enough to leave at the expiration of the tenure. In the final analysis, we found the appeal to be meritorious. The appeal is allowed. Parties shall bear their respective course. As the appeal allowed. That was the unanimous judgment of the court.
That's the official proceeding from the court regarding Labour Party chairmanship position. Now, ever since that ruling came up, there has been a lot of controversies and different positions regarding the judgment. But you've heard what the Supreme Court said, you've heard what the judges said. It is explicit, clear, that the courts do not have the position to determine party affairs, that parties should go home and solve their issues. Even the Labour Party handle is claiming victory for Julius Abure, and they equally released an official statement claiming victory for Julius Abure.
Supreme Court upholds Abure as national chairman, says only parties must decide their leadership. The Labour Party, however, hails the judgment. The Supreme Court today, April 4, 2025, gave a judgment in the case brought against the Labour Party. In this judgment, the Supreme Court said the matter is purely an internal affairs of the political party, of which courts have no business to dabble into them. The Supreme Court insists that the lower courts should have declined jurisdiction and shouldn't have made pronouncements on leadership of a political party. It therefore struck out Senator Nenadi Usman's appeal at the appeal court and the Labour Party suit at the trial court. The Supreme Court judgment didn't sack Labour Party National Chairman Barrister Julius Abure. Rather, it rightly upheld the precedents and the accumulated High Court and Appeal Court judgments, upholding the immutability of responsibility of Labour Party structures to choose its leaders. The judgment did not also set aside the Appeal Court judgment in Labour Party versus Ebiseni and two others, delivered on the 13th of November 2024, which affirmed Julius Abure as the national chairman of the Labour Party. The judgment is still valid and subsisting and has not been appealed. The implication is very clear. Barrister Julius Abure remains the national chairman of the Labour Party. The question, however, is, who are the leaders of the party? The party constitution is very clear as who are the leaders of the party. The leadership of the party has been and has always been the National Working Committee as led by Barrister Julius Abure. The party constitution is also clear on who has the power to call for the National Convention or any national meeting. Article 14 of 2024 Constitution as amended gives powers to the National Secretary of the party to issue notices of meetings of the National Convention, National Executive Council, the National Working Committee in consultation and approval of the National Chairman. Accordingly, the National Convention of the party was called by the leadership of the party on the 27th of March 2024, where the leaders of the party emerged. The report of the National Convention is already with the INEC, and that leadership is recognized by INEC. The gathering of people in Umuahia is clearly not in line with the Constitution, and therefore the celebration by some persons that the leadership of Julius Abure has been sacked, we are only trying to be mischievous and misleading, and that the Supreme Court did not in any way say so. The leadership of the party is therefore satisfied with the judgment of the Apex Court, which goes to reaffirm Barrister Julius Abure as the national chairman of the Labour Party and the current National Working Committee as elected and endorsed through the internal mechanism of the party statutory organs in line with the party constitutions. We are therefore calling on all true members of the Labour Party to abide by the judgment of the Apex Court and to always resort to internal party mechanism in resolving party affairs and not to always rush to the court. It is only the political parties that have the powers to choose its leaders, not the courts. Everybody must learn to respect the decisions of the party and its constitution. The position of the Supreme Court is that the structures of the party is capable of handling any matters as it concerns its affairs. And as it is today, the Labour Party's national chairman remains Barrister Julius Abure. Thank you so much.
For the records, it was Julius Abure that went to court to ask courts to force INEC to recognize him as a chairman. Julius Abure's tenure has expired 6th of June 2024. This was the reason why INEC failed to recognize him as the Labour Party chairman, and because the convention that was conducted in Nnewi did not follow the due procedure. According to INEC, there was no INEC official to observe the proceedings. Since INEC failed to recognize Julius Abure as the leader of the Labour Party, there was a leadership lacuna in Labour Party. Hence, the Labour Party stakeholders convened a meeting in Umuahia and appointed a 29-man committee to steer the affair of the Labour Party. The committee is being chaired by Nenadi Usman. While Julius Abure is praying to the court to force INEC to recognize him as the chairman of the Labour Party, he is equally asking the court to disqualify Nenadi Usman as the interim chairman of the Labour Party, of which the court answered his prayer. But then the Supreme Court is saying that the court do not have the jurisdiction to rule on party internal affairs, that the party should go home and solve their issues. What this means is that the initial ruling by the court asking INEC to recognize Julius Abure as the chairman of the Labour Party is invalid. It is null and void. What this ruling equally means is that the position of the party stands. And what is the position of the party? That Julius Abure's tenure has since expired on the 6th of June 2024. That the meeting that was convened by the stakeholder in Umuahia, which appointed a 29-man committee member to steer the affairs of the party, remain valid. That is the position of the Labour Party. Therefore, the ruling is clear. There is no confusion anymore. Julius Abure is long gone as the chairman of the Labour Party. Whatever they are trying to do is just the last kick of the dying horse. They had the opportunity to reposition themselves and make themselves to be seen by Nigerians as lover of democracy, as people that want to work with Mr. Peter Obi, but they went behind and tried to scuttle the effort that Mr. Peter Obi made during the 2023 general election. Without Mr. Peter Obi, there will be nothing like Labour Party. Mr. Peter Obi gave Labour Party the clout and the national appeal that it currently has now. Julius Abure and all his national working committees are just trying to destroy the effort that Mr. Peter Obi has worked so hard to build with the Labour Party. He was given just one job: conduct a convention. This convention will have to go from the ward level to the local government level to the state level and the national level. This convention is going to incorporate everyone, especially the obedient, that worked tirelessly to ensure that Labour Party got the victory that she deserved during the last election. But this is the reason why you see Mr. Peter Obi has gone on his way to annex the obedient from the Labour Party. The obedient is a different arm from the Labour Party currently now. The obedient movement is currently being led by Tanko Unisa. With this ruling from the Supreme Court, I see a robust Labour Party. I see a party that is going to be built from the grassroots. I see a party that will take over national politics in this country. Thank you for watching. I will see you in the next video.